Well, thanks so much for joining us. I'm Jonathan Armstrong. I'm with Cordy in the UK. Eric Sinrod is with me in California. And the last film we did in this sort of TechLaw10 online series was about ChatGPT and AI. And we've had some really positive feedback on that. So we thought we'd look at another aspect of a tangential topic, if you like, whether ChatGPT and offerings like that can be liable for things they do. And you had some thoughts from a US perspective, Eric.
I do indeed. So good morning from here, good afternoon from there, and good morning from wherever you are at any time when you watch this. The question presented, at least on my end, is should ChatGPT and other AI tools be protected by Section 230 of the Communications Decency Act, otherwise known as the CDA? As a refresher, Section 230 generally provides that internet service providers are not liable for content posted on their sites by others. Section 230 was enacted in the mid-1990s, long ago, by Congress with the intent really to allow for a potentially flourishing commercial internet here in the United States. Back then, startup companies did not have the resources to police the content on their sites by calling balls and strikes. Jonathan, that's baseball. On content, ISPs might deem acceptable or not. And with Section 230 in place, they were alleviated of that legal responsibility and also tremendous burden. However, I should point out, as a matter of law, that Section 230 immunity can end to the extent an internet service provider, an ISP, becomes responsible in whole or in part for the creation or development of the content on its site. Thus, again, generally speaking, companies like Facebook, for example, are not liable for posts, wholly created and developed by other people, just like you or me. I mean, if Jonathan, if I post something on Facebook and it's harmful and say it defames you, which I would never do, of course, and there's nothing negative anybody could ever say about you, Facebook's not responsible. I would be ultimately. But now we are in the new world. There's always a new tech world, and now we're in the new world of AI with tools like ChatGPT. So can ChatGPT be legally responsible, and that obviously the company out behind it is OpenAI, be legally responsible for the information it sets forth online, given that it appears at first blush, to at least be participating in the creation or development of content? And I will briefly, very briefly, flesh out the arguments on either side of the divide. So Section 230 is already under attack, as some tech companies, of course, are no longer startups. And in fact, some of them have the highest financial worth in the world. There are still some startups, of course, but some are very big. And those attacking the breadth of Section 230 believe that these tech behemoths should make sure that information posted on their sites is accurate and not harmful. These detractors of Section 13 might be even more emboldened in arguing against Section 230, protecting the likes of ChatGPT, arguing that it is in fact participating in the creation of content. That's the argument. And interestingly, there are reports that Senator Ron Wyden and former House Representative Chris Cox, who authored Section 230, have intimated that it does not grant legal immunity for generative AI. So, Jonathan, is that the end of the debate? Of course not. Let's consider the other side of the issue briefly. So bear in mind, I'm a lawyer. I'm not a software engineer geek, but let me do my best in setting forth the counter argument, and there's a bit of tech to it. The counter is that ChatGPT simply uses predictive algorithms and a universe of data harvested from publicly available information to respond to user prompted inputs. That's simple. As such, the AI is not advanced enough, footnote, at least as of yet, to operate outside of human assisted control. Accordingly, AI products like ChatGPT are functional cousins of ordinary search engines like Google that have been held to have Section 230 immunity. Like search engines, ChatGPT, the argument goes, does not actually create, develop, or invent information outputs absent a user query, and in responding, it simply utilizes publicly available information. But in rebuttal, one might wonder if the manner in which ChatGPT assembles information in responding to a query actually rises to the level of creating or developing content. And so the debate starts and likely will accelerate. There are those who fear the coming AI tsunami and what it will mean for society. And on the other hand, there are those who fear the stifling of a very valuable AI tool without Section 230 protection. So, Jonathan, my esteemed colleague, so brilliant, ever thoughtful, what say you on this topic and related issues?
I think it's fascinating. I think from a European perspective, we'd recognize similar defenses in the law in many European countries. We sometimes call them mere conduit defenses. But I think one of the interesting bits is almost what ChatGPT and other similar tools think is the legal position versus what it might be. I tried to check the legal position according to ChatGPT today. Unfortunately, it's been down today, UK time. They have these times when they're down. They say because it's high demand. Some people say because they're trying to push you into a subscription service, which I don't have. But I'm reliant on an article that Jennifer Gaskin wrote in Corporate Compliance Insight, where she asked ChatGPT if it could be liable for things like copyright infringement. And no surprise, it said, no, I can't.
Of course.
And I know I've said it before, but a lot of these AI tools behave a bit like candidates on The Apprentice, it seems to me. If they don't know the answer, they say confidently what they think is the case and then sort of double down. And I think we've certainly had that with chatbots, particularly saying, well, we can't be liable for any legal issues. And I just don't think that can be correct. You know, if we look back in time, one of the sort of tests we had in UK tech law was as long ago as 1996, when we had the first case in Scotland called the Shetland Times case. And in some respects, there are parallels between that and modern chatbots. As you say, they rely on harvesting a lot of data from other sources to create their answers. And the Shetland Times case was a bit like that. Somebody set up a rival newspaper on Shetland. Who knew there was a market for more than one news source there? And provider A scraped content from provider B to get a leg up and to get a head start. Very familiar in the chatbot world. And the courts effectively said that that was in breach of the terms and conditions on the website, and that as a result, the website that had been scraped could sue. And I think that's exactly the same here. We forget, don't we? We say just because something's publicly available doesn't mean to say it's a free for all. In GDPR terms, you still have to follow GDPR. And in copyright terms, there's still a number of issues there. First of all, the original provider, the scrapee, if you like, the site where the data's scraped from, they likely have copyrighted some of the content. And in addition, they may have terms of service that say you can't scrape our site. And those terms of service themselves could potentially, in the UK, for example, found a criminal action, because under the Computer Misuse Act in the UK, even if you visit a site lawfully, if you then perform an unlawful function on that site, that in itself is unlawful. And just because we alter the format of something doesn't mean to say that copyright doesn't apply. So to give you an example and to frighten you, if I pick up my bongos and if I was to play, for example, the introduction to We Will Rock You by Queen, which is about the limit of my bongo playing ability.
Wait, we're waiting for it. We're waiting for it. Come on.
Well, why I'm not going to do it is I then have to pay royalties to Brian May or whoever the copyright holder is. And just because I've created a new work that derives from their work, that doesn't absolve me of the right to pay royalties. And even if I say in a contract with you and our dear TechLaw10 listeners and watchers, I will not be held liable to pay royalties to Brian May, that doesn't absolve me of my legal responsibility. So if these regenerative AI producers have terms and conditions to say we shall not be sued, then that could, and I emphasize could, hold them harmless from litigation against the person who signs up to those terms and conditions, but it obviously doesn't bind a third party. So I think just as many answers that we get from regenerative AI are a bit smoke and mirrors and prone to inaccuracy, then I think that's the case with answers on things like whether they're mere conduits, whether they're liable for copyright infringement, etc., etc. Now, of course, we are starting to see cases. I believe Getty Images are suing Stability AI because they trained their bot on a load of Getty images. Getty are traditionally very protective of their intellectual property rights, and they say that scraping our images for training purposes is still a use of those images. So from what I understand it, there's some litigation ensuing on that. We have a proposal at an EU level with a new draft AI liability directive. It's a directive, not a regulation, so not the same legislative process as GDPR. It will rely on member states more. It's probably about 5 years away, but that will try and address some of these issues. It'll have some liability provisions for creators or operators. It'll have special rules on evidence and switching burdens of proof, etc., etc. But I think in those intervening 5 years, we don't want people to think that this area is law-free. Sure. There's lots of law, and cases like, old in internet terms, cases from 1996, I think still give us guiding principles to where liability might lie. And then 2 last points, if I may. I think people are already suing over this. We've had today, I think, an FTC complaint about GPT-4 already, saying that GPT-4 is biased, deceptive, a risk to privacy and a risk to public safety. So expect complaints to regulators. I think it's relatively easy to make out a case that some of these chatbots are deceptive. If they give wrong answers and that misleads people, then that could be a misleading trade practice, etc., etc. And then another point I'd make, I think it's something we made in the last film, but worth emphasizing, not all chatbots are equal. I've done quite a lot of work looking into replica AI, for example. Just after our last film, the Italian Data Protection Authority suspended replica AI over some issues that it had with the answers it gave. There's a whole other story on how replica AI has treated some of its subscribers, which I uncovered after some of them reached out to me after I wrote an article. But there is at least an allegation that some of the funding for replica AI comes from the Russian secret services, and that in part the role of it is to spread misinformation, is to give deliberately misleading facts on the Russia-Ukraine war, and it's to gather information from countries that Russia regards as hostile to it, and potentially, I think, compromise the security of individuals and corporations in the West. So, as well as looking at liability, I think we can't be completely forgiving and saying this is cutting edge technology with the purest motives, because I don't think that's the case, at least in every single iteration of AI we see. So I suspect we're going to talk about liability issues for many years to come, but does any of that resonate with you, Eric?
Oh, yes. So thus spoke Jonathan Armstrong. He's intelligent. He's not artificial. And I just have a few quick points because I know we're over our 10. You point out how, a chatbot like a chatbot might just say, no, of course we can't be legally liable. I guess that means lawyers still have a job, because that's just a little bit too categorical. Also, I do actually have the paid subscription. I subscribe sort of accidentally. And generally when I ask, difficult questions of ChatGPT, it will hem and haw and then basically say, it can't answer the question. I'm sort of thinking, as our political season starts ramping up here, we'll be having a presidential election in the not too distant future. I'm guessing this is going to become a political issue, people taking sides and using it, either pro or con in their political campaigns. I learned a new word from you, scrape-e. I'll have to figure out a way to use that. Maybe at the dinner table tonight, I'll refer to somebody as a scrape-e, maybe when they're getting food off the tray. And then I'll just never be able to unsee and unhear the image of you playing bongos to We Will Rock You. So thank you for that. So this is Eric Sinrod at Duane Morris. My email address is ejsinrod@duanemorris.com. Thank you for joining us on this intelligent and not artificial ride. Jonathan?
Yeah, thanks much. And thanks for making that contrast, of course, between AI that makes stuff up and then doubles down on it, contrasted, of course, with many US presidential candidates who would never do that, would they? I'm Jonathan.Armstrong at CorderyCompliance.com. I guess all that remains is to thank you all for listening or watching. And do join in the debate. We'll post this on our LinkedIn channel. If you want to debate on there, then do. And Eric and I'll hop in from time to time and see what you're talking about. If you have other topics that you'd like us to discuss, then just drop us an email or shoot us a message on LinkedIn as well. And so thanks for watching.
Take care.